people win these claims because she's like, it sounds really hard, whether it's arbitrary and capricious standard of review, which we've talked about in our other videos, or de novo, you have to wait so long. The insurance company sweats you out. They come up with all of these excuses. And I said, you know what? Yeah, it's not a level playing field often. The insurance company has the upper hand, especially if it's not a de novo review, but people do win these claims. And lately, especially around the country with Unum, there's been a lot of decisions coming out against Unum where claimants have won. And mental nervous claims like this one, in my opinion, are some of the hardest claims to ever win. Hi, I'm Greg Dell, here with attorney Stephen Jessup. And Stephen, we're going to talk about a recent court decision that came out of the Southern District of New York Federal Court. It was a Unum disability case. I believe this one was First Unum Life because that's their subdivision of New York, which is a technicality, but for all intents and purposes, it's Unum. And what I like about this particular case, which was not handled by our firm, but we track every case across the country, and this was a great decision for a claimant, and one that actually what I really like about one of it that relied upon a case that we had just won in the Southern District earlier this year, and the judge cited our case. So it's really great how when the law works in the favor of the claimants, that this positive case law that makes good findings for claimants continues to build, and other claimants around the country can use the case law. And we're usually at the forefront of making case law for claimants, and this is another example of how another claimant was able to benefit from that. But one of the things I want to talk about in this video is about this claimant was an employee of McKinsey. And McKinsey is one of the world's largest and one of the top-rated, if not the top-rated, consulting firm in the world, certainly in the United States. And there's a handful of the top 10. But we've represented numerous McKinsey claimants over the years and very familiar with the substantial material duties and demanding job responsibilities of that job. Now, I was an accounting major in college and studied finance as well, and half of the student body coming out of business school wanted to go work for a top consulting firm. I have a son who's in college, and all of his friends want to go work. The dream job is to go work for McKinsey if you're a finance or accounting or some kind of business major like that. So the demands at McKinsey, from what we know from having represented so many, from handling so many of these claims, from seeing the job duties, from working with our vocational consultants, from you and I having friends over the years that work in McKinsey, we have such a strong understanding of what it takes to do that job. We also have a very good familiarity of their disability policy, which has nuances, which is actually a pretty good policy.
Yeah, like we were talking, it's like an old school style, even down to using font that they haven't used in like 15, 20 years. It's an overall good policy that they wrote.
And it's interesting that despite the fact that we have seen many, many denials of McKinsey employees, we've seen many get approved, that maybe, McKinsey's holding on to this policy with Unum because they like the language. Unum's happy to, because they collect a big premium, a real hefty premium for this policy. So, Unum's doing their cost benefit analysis and keeping the policy, but Unum is very tough when it comes to handling these claims. And we're going to use this particular case as an example as to the challenges of what this particular McKinsey employee had. And we'll talk about what her diagnosis is, which is probably one of the most common diagnoses that we see from McKinsey employees, and also many employees that are in these very fast-paced, very demanding, very high-pressure type jobs, and not necessarily high pressure from the work environment of McKinsey, but more from the demands that you're the outside consultant who's coming to a corporation, company who's saying, we have a problem and we want you to solve it. And we're banking on you to give us the solution or help us get there. That's pressure any which way that you cut it. It's very demanding. It's very time sensitive. You got to be involved. So let's talk a little bit about the facts of this case, just in terms of what the person's job responsibilities, meaning what was their disability? Why did they file the claim? We'll look at how Unum, evaluated this claim, and then the positive outcome that came out of it for this particular McKinsey employee.
Yeah, so on this particular case, she was a consultant, I believe, if I'm not mistaken, more along the lines of like cloud data storage, IT type stuff. like you were saying with regards to, the premiums that are paid in this, claim. The case opinion even goes so far as to say what her monthly benefit was supposed to be, which is only 60% of her prior earnings. It was $24,000 a month that Unum's to pay her under this claim. So, of course, they're going to look at it with scrutiny, try to find ways of denial. And then I think the biggest component as to why her claim was for mental illness, which is very common. It's one of the most common reasons for disability in the country. But in it, so much of it is subjective, right? The argument, there's no way to objectively verify how you're feeling, what's going on. So insurance companies really attack those types of cases. And ultimately, in this decision, just to kind of get ahead of ourselves a bit, Unum tried to paint it as your condition is not something that's impairing. It's a job-specific, environment-specific thing that, but for the stress that you have in the job or the issues you have with coworkers or people within the company, you'd be able to work. And because the policy, though good, still uses this idea of, your job is performed in the national economy, not for your specific location or employer. They almost tried to argue, well, if you were doing the same job for a different company, you wouldn't have these issues. This is just because of this specific company. So that was kind of the framework by which they were really looking to try to deny the claim.
And I know this claimant, it was interesting because Unum will take any excuse they can to try to say it's not a medical condition, it's a choice, or there's nothing wrong with you. And here, this particular claimant was complaining of a toxic work environment. She was complaining of toxicity with the clients that she was representing. So whether or not that existed or not doesn't matter. Maybe it was part of her mental condition.
I'd argue it's a symptom of the condition.
Yeah, that she thought everyone was being toxic towards her. Maybe they were, maybe they weren't, maybe it was. We don't know. It wasn't a factor. But Unum heard that and goes, no, this is your personal choice. You just don't like the people you're working with. There's nothing wrong with you. But what I like about this case that I want you to talk about, and first of all, the court did such an unbelievable job of summarizing all the treatment. It was a 37-page opinion.
Very long.
I've never seen actually such detail of every single, basically almost every single office visit, every key thing that was said. To this claimant's credit, she tried to go back to work. I think she went out for 3 months and then...
It was after the denial of the long term, she attempted to return to work. And I think, too, in the transition from short to long term, you see that happens on purpose. So the insurance company is almost like, well, maybe we'll just go back to work. And that did happen here, but she tried to go back with accommodations and she went out relatively soon thereafter and then went through her appeal process.
What blew us away, considering the magnitude of this being a $25,000 a month benefit, the way in which Unum initially reviewed the claim, what did they do? What did they do initially to review the claim? Because I was shocked that that's all they did.
Initially, a nurse. Yeah, initially there was a nurse who reviewed it. I think later the court would argue that nurse didn't have any indicated specialization in psychological conditions, so it didn't give much weight. But initially it was a nurse. And then they did have, through the course, the way the court describes it kind of, goes into with the appeal. They did eventually, I think, get up to like 5 doctors looking at it. It was almost like Unum was trying to compete with the number of doctors she had, treated with them. But it was originally just a nurse going through and, not finding the restrictions and then having, I think one of their medical officers for Unum then looked at and basically rubber stamped it.
What I like about, fast forwarding a little bit through here, because a lot of people, I was with a client the other day and the client goes, do people win these claims? Because she's like, it sounds really hard, whether it's arbitrary and capricious standard of review, which we've talked about in our other videos, or de novo, you have to wait so long, the insurance company sweats you out, they come up with all of these excuses. And I said, you know what? Yeah, it's not a level playing field often. The insurance company has the upper hand, especially if it's not a de novo review, but people do win these claims. And lately, especially around the country with Unum, there's been a lot of decisions coming out against Unum where claimants have won. And mental nervous claims like this one, in my opinion, are some of the hardest claims to ever win. And the reason for that, which you've talked about, is, which we started in this video, was they're subjective. There's no machine that anybody can go to say, hey, Steve, yes, you're depressed. No, you're not. You're full of it. Or, yes, you should be feeling anxious now. No, you're not. We can't, if you're sitting there right now telling me you're anxious, whether you are or not, there's no machine I can put on you to say you're telling the truth or not. It's not a lie detector machine or something like that. So that's the way this medicine is. It's not an exact science. So it comes down to your credibility and what you're saying. And what was so interesting about this case and positive for a lot of people who have these claims is that, like you said, Unum had 5 doctors review the claim. She had 5 treating doctors. What was the deciding factor for the court as to why the court went with the claimant instead of Unum's 5 doctors?
Yeah, so that's kind of an answer that you got to kind of step back and take a look at with it as well, because I think it's important to note that Unum was also trying to make it seem like she was shopping doctors, because she maybe have an appointment with one, whether it was too long to get the next one, she switched doctors. But even a doctor that it seemed like she almost had a level of falling out with was still very supportive of her. I think this is all a symptom of her condition. So when it came down to it, one of the big things here, and a nuance that I think definitely helped the case, because, this policy would fall in line with typical, New York, which was the idea of an arbitrary capricious standard of review. However, Unum failed to render a timely decision. And as we know, in that case, if they don't do it within in the allotted amount of time, there's been no extensions, tolling, whatever the case may be, you can file a lawsuit and get a de novo review. And that just means that the judge, as she said in her opinion, just has to look at the preponderance of the evidence to determine, who wins the case, if you will. And in this one, since they failed that, there was an agreement it would be under de novo. Unum must have been feeling pretty confident about ability to win this case. But she did go and say that she could weigh the opinions of the treating physicians as higher because they'd actually physically examined. They'd actually spent time with her. And then even quoting the case, citing the case that we had won earlier this year, also saying that, to dismiss certain doctors, that people that are reviewed, that the opinions of a specialized treating physician carry more weight. So she really took a look at what both were saying. And I think also the judge was really trying to set up their opinion in a way that it wasn't going to be something that could be easily tried to be undone by a defense attorney, and gave more weight to the treatment providers as the ones who have been actually seeing and treating her and spending time with her. Because when it comes to a psychological condition, the only way you can really get an impression is not from looking at paperwork, it's from speaking to the person. And that was, I think, a very large undoing for Unum in not doing that. Maybe they probably even in the back of their minds realized if we do, we're going to be on the hook for this. Because very unique to this policy, since it is, you see it's only like 20-some pages long, where most are 40 plus. There's no limitation on mental health conditions. So it's a lot of money they could be paying out. So maybe they don't want to risk finding it there. So the judge did weigh what they did. She didn't give any deference or say, well, I can't give deference to one or another, and went with the treating physicians over. And it was really well done. And one thing that really stood out to me in the findings in the opinion was something we run into a lot, where someone's doctors don't want to fill out APSs, attending physician statements. And Unum had argued in the case, well, only one doctor was certifying disability, and she stopped seeing him in July of this year, and no one else was certifying after it. And the judge went and said, no, that doctor may have been completing an attending physician statement, but that's not the only certification. Read the medical records. All of the doctors she saw after that were still asserting restrictions and limitations. They didn't need to fill out a form to formalize those restrictions and limitations. So, insurance companies require these forms to be completed. But I found that stood out to me a lot. It was like a one-line little thing that really stood out to me, because here's something to argue from a case law perspective. If you can't get a doctor to complete an APS, but the records are supportive, some companies like MetLife will say if they want an APS, or they'll be like, or give us the 3 most recent treatment notes. So I thought that was something really that the judge was really advocating strongly for the individual on this one.
The one thing to give a tip for someone out there who has a psychiatric claim, or any claim for that matter, is it seemed like this particular claimant had good documentation of her complaints in the medical record.
Very good.
And that's unusual with psychiatric claims, because a lot of psychologists and psychiatrists, they treat the patient, not the chart, and they build relationships with their patients. So they might have 1 or 2 lines in there of just very few things. It's not normal to see a lot of notes. I've gone to many where they go, yeah, I've been treating this patient for 2-3 years. I don't have any notes, but I'll put something together for you, because a lot of times it's cash pay, because health insurance doesn't pay for this. And so she was fortunate to have that kind of documentation, because if she didn't, there wouldn't have been anything to say, hey, where's the documentation of your claim? Where's the things that like all the different things are going on? Like when she didn't show up for work at all, or she's like, I can't even get out of bed today.
Yeah,
or
I mean, it was so bad that McKinsey called the police to have a wellness check done when they didn't hear for 24 hours, which to me also goes to show how demanding the job is. 24 hours, they haven't heard from you, like one calendar day from the day before, and they're calling the police to make sure you're okay.
But I can say that Unum was not going to accept her claim under any set of circumstances.
Yeah.
I mean, when they go to 5 different psychologists and psychiatrists and keep trying to say, no, that's not enough, this is not enough. And I'm like, what more was she supposed to do?
Well, and not only that, but during the appeal, had neuropsychological exam done that supported all kinds of limitations due to the mental health condition, a vocational assessment done. I believe they maybe even had an independent review done by an independent psychologist to render an opinion. So, I mean, anything you could add to this case in appeal, they added to this case in appeal, and Unum was just going to toe that party line, and nothing, like you said, was going to be good enough.
Well, that's the MO lately for Unum, unfortunately, but the courts are seeing right through it, and they're being reasonable because they don't have a stake in the game, and claimants are winning. But it's sad. It's a long road.
It takes long. You're years down the road to get that decision.
It's really pathetic, and glad that this claimant hung on to ride this out, and who knows if there were settlement negotiations or whatever along the way, but Unum wasn't going to pay, and Unum's like, you know what, if the court makes us pay, we'll pay, and we'll see if Unum's going to appeal this. I doubt it. That opinion was basically ironclad, but it was another great victory, good case law, and it should be a message to Unum, stop screwing people who are rightfully entitled to benefits, and, don't just evaluate a claim and just go through the motions, but ignore what you're hearing from the other providers. And more importantly, on a mental nervous claim, like you said, just examine the person. What was the reason? Why would you have 5 people review it on paper on a subjective complaint? Like, would they hire someone just looking on paper and never speaking to the person? They don't care about the human who's behind the paper, because they would never hire an employee without ever speaking to that person. It's a typical outrageous denial. It still shocks us after seeing thousands and thousands of Unum denials, and I'm really happy for this. And I'm happy that there's a permanent record for the whole country now to see. And we have plenty of lawsuits pending against Unum, and we're going to use this one.
And it was nice to see the case we won this year against them, quoted by the judge. So, 2 cases. I'm sure there's more directly that they lost in the Southern District of New York.
Yeah. So if you are someone out there who has a Unum claim, especially if you're a McKinsey employee, feel free to reach out to Stephen, myself. No matter where you live in the country, we're available to assist you, and we'll always provide you with an initial free phone consultation.